the probably most important historic collection of laws in Eastern Africa. The Fetha Nagast, literally the law or justice of the kings, is a theocratic codification and standardization of laws, originally compiled around the 13th century by the Coptic Egyptian Christian writer Abu al-Fadail ibn al-Asal in Arabic. It was later translated into Ge'ez, the Ethiopic language at that time, in the Ethiopian Solomonic Empire, and added upon and changed to fit the Christian legal traditions of the Ethiopic church tradition that was present there. The Fetha Nagast is divided into two parts. The first part of Fetha Nagast deals with mostly ecclesiastic affairs, outlining the structure of the church hierarchy, sacraments, prayers, rituals and such matters that relate only to the church, and rules and laws regarding Christian worship. This first part remained largely unchanged, with just minor changes, mostly attributable to translation interpretations, natural changes through translation, from Arabic to Ge'ez. The second part of the Fetha Nagast concerns issues pertaining to the laity and to the world beyond the church and the direct worship of God, such as family law, debt law, laws regarding civil administration and rulership, that is to say, rules regarding the treatment of others. This part was heavily altered and made to conform with a lot of the local practices found in the Ethiopic Empire at this time, when the Fetha Nagast was translated and changed over to fit the Ethiopic legal traditions. Yet it should be mentioned that this second part, just like the first part of the Fetha Nagast, takes Old Testament scripture and Ethiopic biblical literature, the Ethiopic Orthodox Church having far more canonical biblical literature than the Roman church traditions, such as the Didaskalia literature and various other texts in their biblical canon, and other Christian literature, such as consensus literature about interpretations of Christian literature, and cites them as sources for legal judgments. And thus, the Fetha Nagast is an example of codified divine law from God and the examples of his various prophets and of Jesus. And Strauss, in the introduction to his translation of the Fetha Nagast, notes the numerous references to the Holy Scriptures, the church councils, and the writings of the fathers of the church permeate the work with a spiritual ambience. In short, the Fetha Nagast should not be seen as a secular law in any way. In fact, even the laws outside of the church and direct worship are also sacred laws, holy laws, and spring from far older Ethiopic Axumite traditions about holy law, where there is no great distinction between religion and the secular, and the tendency to blend secular with religious, a tendency common to the Fetha Nagast and particularly to be found in its penal sections, has contributed to a conception of law as something intrinsically sacred in character in the Ethiopic legal traditions. And the now unfortunately gone old professor in Ethiopian studies, Richard Pankhurst, may he rest in peace, noted that the Fetha Nagast was based essentially on exegesis, the selected use of the Bible, for its laws, in a way that was quite unlike European traditions of law, that were more indirectly inspired by the Bible, rather than trying to directly apply the judgments found in the Bible as a direct law. Though in practical terms and in actual law, it seems kind of similar to a mix of Byzantine Roman law and Jewish religious halakha law, with which it shares a lot of the Holy Scriptures, as Judaism and Christianity share the Old Testament, and the way of thinking in interpreting the Holy Scriptures as a basis for a law to structure society with. The Fetha Nagast is not only filled with a lot of similarities with Jewish law, but interestingly enough, with a lot of similarities to the Islamic Sharia. Though in this later case regarding the Sharia, I would argue that it is due to similar origins and thinking behind it, this being a divine law, interpreted directly from Holy Scripture, from similar religious traditions, both Islam and Christianity being Abrahamic religions. It should also be said that certain parts of the Fetha Nagast and certain legal ideas in it predate Islam and go far back to the earlier periods of the Axumite Empire period of Ethiopic history. Thus, any similarities with Islamic law is not due to Islamic influence upon Ethiopic traditions, and thus the Fetha Nagast, but more probably due to convergent cultural evolution and developments. Though on the subject of similarities to Islamic law, Peter Hayes Sand describes the Fetha Nagast as a combination of Islamic fiqh, Islamic jurisprudence, and Roman law in style and influences. Though he also notes that it is closer to fiqh than jus civile, in that it is derived directly from religious literature. Though it should be said that Axumite legal traditions already had this, and previous legal literature shows the same pattern as we can see in the legal codes of the Fetha Nagast. In the second part of the Fetha Nagast, the part about the treatment of others outside of worship and the church itself, the Fetha Nagast shows to be a blending of two legal traditions. The legal traditions of the supporters of the consensus tradition, those that wished to create a legal tradition based upon consensus of the church scholars, of the Christian judicial experts regarding the various biblical sources and the like in the Ethiopic traditions, and those that wished greater respect and integration for local customs in the divine law of the land. These differences between these two schools being kind of similar to the differences between the Shafi'i and the Maliki schools within Islam. And the law code of the Fetha Nagast was kind of a compromise between these two traditions. As a medieval law code based upon direct divine law as found in various biblical texts, the Fetha Nagast includes various typical for its time physical punishments such as the cutting of hands, stoning, and other types of physical punishments. It also includes laws about slavery, for the taking and selling of slaves and buying and the treatment of them, based upon various biblical and consensus-based arguments for it. That is to say, very much typical laws that you would expect. What is probably less expected by many people is that the Fetha Nagast actually includes a lot of law regarding the rulership and its limitations and definition, and outright states that the ruler must follow the divine law in the Fetha Nagast and as outlined by various other traditions. It is the function of the ruler in the Fetha Nagast to implement the divine law found in it. And a ruler is illegitimate if not a follower of the true faith in thought and in action, in the implementation of the divine will. And he must thus be a believing Christian following this law. And it should also be pointed out that the penalty of apostasy away from the true faith in the Fetha Nagast is death. And it's in the chapter, either 2 chapters afterwards, after the chapter dealing with the rulership, or in the chapter directly after, depending upon which version of the Fetha Nagast you have. So it's quite clear that you must be a believer and follower of this divine law in order to be a legitimate king and not face rebellion. So the Fetha Nagast includes a lot of limitations upon the rulership in order to define it and control it and subjugate it. If the ruler does not follow the Fetha Nagast, rebellion becomes legitimate against him. And despite being translated as the justice of kings, the Fetha Nagast could also be actually translated as the divine's justice over rulers, rather than the justice of rulers. So it's rather God's justice regarding rulers. Traditionally, the Fetha Nagast has been closely tied to the kings whose law it is, as well as to the church. So it's a law to control power as well. And the legal traditions in the Fetha Nagast and around the Fetha Nagast also developed independently of the rulership to a great extent, and were used to hold rulers accountable, both in theory and in practice. For example, Emperor Joas was in conflict with Ras Mikael, a leader in the Tigray region, in the 18th century, where the Fetha Nagast was called as a source in favor of Ras Mikael's rebellious acts, which had caused the conflicts, as they were legally deemed as an act of piety in accordance with the faith and the Fetha Nagast, in favor of Ras Mikael against Emperor Joas in that conflict, after the dust had settled. And Abuna Salama, a high priest in the Ethiopic church in the 19th century, also in opposition to the later emperor Theodros, refused to hand over prisoners, citing the Fetha Nagast and the laws therein preventing him from doing so. So the Fetha Nagast was in practice used as a legal document to bind the power of the rulership in Ethiopic history. Bind them through the judgments of the judges. The judges were supposed to be men of religion who interpret the law that is given through both direct divine command from God and through both prophetic speech and actions in the Bible and related literature. The Fetha Nagast is a law code based upon an ideal of orthopraxy with a focus upon correct, divinely guided praxis, and is quite different from any Western law code, even the Catholic canonical law tradition, which is mostly based upon ideals about intentionalist law creation rather than direct divine command law praxis. And the Fetha Nagast is the greatest example, though not the only one, of codified divine biblical law in the Axumite Ethiopian tradition. It did not replace other previous traditions and laws or law codes, but it did become a fundamental part of the judicial law traditions of Ethiopia and of Eastern Africa. And the Fetha Nagast remained officially the supreme law in Ethiopia until 1931, and to this very day parts of it is still included in the legal systems of Ethiopia, as it is still consulted in matters of law in the present era, even if in a rather reduced form. And the first part concerning ritual is still seen as a work of canonical weight and religious rulings with regard to the Ethiopic Orthodox Tawahedo Church. And in 1960, when the government enacted the Civil Code of Ethiopia, it drew from the Fetha Nagast as an inspiration for the Codification Commission, still integrating parts of the Fetha Nagast in changed forms into the new civil code. And this was the Fetha Nagast, probably East Africa's most important legal document historically, as the Ethiopian Solomonic Empire, which used this legal code in its judicial system, either dominated or influenced large parts of Eastern Africa, and thus in turn became influenced by this legal code in one way or the other. As the Fetha Nagast, for example, also regulated trade, and Ethiopia was a big part in the Ethiopic-Yemeni-Indian triangle trade network. A trade network I made a previous video about. Please check it out after this video. And I hope you found this interesting. If you have any questions or other comments, please post them, as I will reply to you. Please do subscribe, as it would help the channel spread awareness about the humanities.
اشتركوا بالقناة من فضلكم.